Assalamu alaikum and welcome back to Just Law on Iqra TV. I'm your host Ilyas Bulbulia. This is the second part to the show. I think we've got a number of callers waiting, so sorry, I think they've had to wait a long time, so sorry about the delay in getting back, but by all means do call back and hopefully I should be able to speak to you live on air. Just before we got the call, or just before we went on our break, we had a caller who'd called in about a visit visa, in particular a visit visa which had been refused a number of years ago based on an allegation of deception having been used in the application. So you don't see many of these refusals now, but it was very commonplace a few years ago, where if there's a discrepancy, the Home Office would very quickly say that you've tried to use deception in the application, and they would refuse it under a particular immigration rule, paragraph 320. The effect of that is that you are then prevented, you are effectively banned from making a further application within the 10-year period. And if you do make an application, they can simply refer back to the previous refusal, refer back to the 320 ban and simply say, we do not need to even consider the merits of your application because the 320 ban applies to you. On a visit visa, the problem is this: even if you manage to convince the Home Office that the 320 ban should not have been applied, so you explain why no deception was used, it was a mere mistake in the application. Even if they're convinced and they say, okay, we accept the 320 deception ban should not have been imposed on you, they will then have to look at the application like any other visitor application, like a fresh visitor application, without the problems that have occurred in the past. The problem will be that they will look at it and they will simply find some other reason to refuse it, because the main issue, the main thing that causes a problem with visit visa applications is that there is a requirement that the applicant has to demonstrate that the applicant has the intention to return to their home country. Now, the Home Office assesses an applicant's intention by looking at the surrounding circumstances. Obviously, there's no way of the Home Office knowing what's in somebody's mind, whether they're going to return or not. So they look at the circumstances around the application. So they may look at, and they do look at, the applicant's financial circumstances in their home country. And this shouldn't happen, but in reality this is what happens. If the person is reasonably well off and can demonstrate that they are reasonably well off, the Home Office then says that we accept that they have an intention to go back. They live in comfortable circumstances, they've got a job to go back to, they've got a business to go back to. So the incentive to return is seen, and it shouldn't happen, but is seen as a good indicator of one's intention to return. The more incentive there is to return, the more likely it is that the Home Office will accept that a person intends to return. The problem with that approach is that somebody like the lady might be in her late 70s, has every intention to return, but financially she doesn't have an income. Does that mean she has no intention to return? We'll look at that in greater detail after we've taken the next call. Hello, assalamu alaikum.
Wa alaikum salam. I have a question about the FLRM.
Yep, okay.
Well, two questions actually.
Sure, fire away. Yep, okay.
One is if the partner of the applicant is receiving child benefit,
okay,
does that come under recourse to public funds?
The no recourse to public funds condition, that only applies to the applicant.
Okay.
It doesn't apply to the sponsor, the partner.
Right. Okay. That's good. The other question was, when the initial application was made 2.5 years ago, we got the housing report and also title deeds.
Okay.
Although they're 2.5 years out of date, can they still be used?
Yeah, they can still be used. It's not a problem. The Home Office, as a matter of practice, doesn't really look at the accommodation requirement in any detail. And to be quite honest, in the applications that we do, and we've noticed this over the months and years of the recent past, that even if you just put the title deeds in, the Home Office won't query it, will just accept it. But if you've got the title deeds and an old housing inspection report, it is more than sufficient.
Okay,
So
that's brilliant.
Because if you think about it logically, if somebody is earning 18,600 per annum, it follows that they've got enough money to, pay for accommodation, to look after themselves financially.
Right.
So there isn't that much emphasis on accommodation anymore at the extension stage and the indefinite stage. There is still some emphasis placed on the accommodation requirement when the first initial visa is granted from abroad. So at that stage, obviously, the housing report and the deeds and all that, whether it's a tenancy agreement, the owner's letter, etc., that's all important. But in practice, at the extension and the indefinite stage, the Home Office doesn't look at the requirement in any detail at all.
I mean, I was looking at the mandatory documents.
Sure.
And I haven't come across the need for housing report at all.
No, there isn't.
Or the title deed.
No. Well, the mandatory documents only really relates to financial documents. So it's your employment letter, your wage slips and your bank statements. And as you rightly say, nowhere in the immigration rules, nowhere in the guidance is there a reference to a housing report. So that begs the question, okay, even when the initial spouse application is submitted, is there a need for a housing report? What most people will do is they'll be cautious and they will submit it. You have to demonstrate that there is sufficient accommodation available, the hazards that normally present themselves in properties, they don't exist. But does that have to be proven by way of a housing report? Probably doesn't. But everybody submits it, so let's just carry on.
Well, now that it's online,
yeah,
it's somewhat easier now because they actually list all the documents that you need to send.
Absolutely. The only thing you need to be careful about, the document checklist you get at the end, it's not entirely accurate all the time. So that's the
okay.
So sometimes it tells you to do some things which don't really need to be done. But you're right, it does help. Essentially, it tells you the kind of documents you need to be submitted. But because there's so many different scenarios you get, FLRM, FLRFP, SETM, SETO, whatever, whoever's designed it all hasn't perfected it yet.
Right.
So
they haven't made it specific to one particular application.
Yeah, it's a bit muddled. But it's a very good guide. I tell you that it's a very good guide. But it's
definitely
it sometimes concerns people. So, for example, if the requirement is that you need to submit 6 months' wage slips, the document checklist will still refer to 12 months, and that will concern people that we're just working for 6 months and now it's asking for 12 months. So sometimes it does concern people, but it's still a good guide, as you say. But thank you very much for your call on that. Now, just on that, we've only got a couple of minutes to go. Just on that, obviously, when you're applying for extensions, when you're applying for indefinite leave to remain, it's possible to do the online application and also follow the checklist. What I would suggest is if you are making the application yourself, by all means, it's not a problem. You don't have to go through a lawyer. If you're comfortable with doing the application, that's all good. What I would suggest is the Home Office does have quite detailed guidance on these applications. So if you are attempting the application yourself, try and download the detailed guidance which the Home Office has on its website, and have a look at it. At least it will give you an idea about how the application process, in terms of the requirements which need to be satisfied, in terms of the documents which need to be submitted, in terms of the format, whether certain documents are out of date or not, etc. The Home Office guidance it is actually quite a helpful document. So it is worth looking at if you are attempting the online application yourself. So certainly I'd recommend that. So it'll tell you about the 5-year partner route, the 10-year partner route. It'll tell you about, let's say on a last caller where somebody's here on a spouse visa, it's coming to be extended at the 2.5-year mark. Very detailed guidance on how you meet the financial requirement. Well worth a read. I mean, even lawyers, obviously, we go back to that document for general guidance as well. It's all available on the Home Office website. So that's where we are. Okay, that sort of brings us towards the end of the show. Today's topic was to do with spouse applications. We weren't really able to get into that in a lot of depth. So hopefully what we'll do next week is to look at that in greater detail. How do you make a perfect spouse application so that the visa goes through the first time round? So in depth, we'll have that discussion next week on Monday at 6 o'clock. Until then, Assalamu alaikum.